Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, this will be a video about Illinois and for Illinois, but it's really for all of you. And it's for all of you because you need to understand that there is a very toxic combination, a toxic cocktail, if you would, of a misplaced footnote in the Bruen case and a bunch of language that didn't need to be in Rahimi, but the Chief Justice found a reason to put it there anyways, that can literally be used to justify just about any type of civilian disarmament legislation. We're going to use a case today out of Illinois. It comes out of their 4th Appellate District. It was a challenge to the FOID card. It obviously was an unsuccessful challenge. That shocks no one, including all the folks in Illinois who've proven to be some of the toughest gun owners in America. But it does, in fact, lay out a playbook where those who advance the cause of civilian disarmament can literally use two of the most recent cases that come out of the highest court in America to justify just about any type of gun control law. I'll show you how they're doing it in just a moment. So today, let's spend a few minutes and let's talk about how this Illinois case is a roadmap for disarming all of you. Okay, Illinois. Anyone who wants to wallow in the misery of Illinois or anyone around America who's concerned that this type of crazy legislation could end up on your doorstep soon, let me introduce you to the case of Guns Save Life v. Kelly. Now, before we go too far down the road, I want you to know that special thanks go out to my good friend Todd Vandermeide over there at Freedom Steel. He tipped me off about this case, was kind enough to send me the case with his highlights on it already. So, Todd, thanks a lot. Listen, if you're not checking out Todd and Freedom Steel, we're going to link them up down below in the description box, especially for the folks out there in Illinois. He is Johnny on the spot, keeping you posted on everything that's going on, and you guys need that type of information. Okay. Where are we going today? Well, I'm going to show you today how we can take Bruen footnote 9, a very problematic footnote that we talked about in this video right here, and the inclusion of terrible, terrible language all throughout the Rahimi opinion, which I've talked about in more videos than I can actually count. And it can be used to, in fact, advance any type of civilian disarmament legislation. In this case, it's a permission slip that the folks in Illinois must get before they can actually purchase a firearm. Or translation, they must go through a serious vetting and a background check before they can go through a serious vetting and a background check. Now, just to let you know where the court was going, whenever you are challenging some type of pre-purchasing licensing, and this is going to be a big issue around the country because we've seen this pop up in Colorado, Oregon, and Washington lately. There's some other states that have already done it, and you know there's a bunch more they're going to think about doing this, okay? But when the Court of Appeals starts their ruling with this opinion, you know you're in trouble. A brief delay in one's ability to exercise a right does not constitute a denial of that right. Yeah, and you know where we're going right there. It's kind of like an assault weapon or magazine ban case when it starts off with 2 paragraphs about a mass shooting. You know where that opinion is going. Now, in footnote 9, and we talked about it again on this video here, we're not going to go too far down that rabbit hole, but the Supreme Court used this objective criteria and said, hey, a lot of these 43 states that got these shall issue using objective criteria, that doesn't suggest that those are unconstitutional. That was meant, I believe, to be a shield from frivolous litigation, but is now being used rather as a sword by those advancing civilian disarmament. And it appears that any kind of inclusion of what could be argued with a straight face as objective criteria will be sufficient. It certainly was for this court. Specific objective criteria must be satisfied for the issuance of a FOID card, including criteria related to an applicant's age, criminal history, drug dependency, mental health history and status, intellectual functioning, and citizenship and residency status. Isn't that amazing how we have to check the residency status of anyone who has the audacity to want to get a gun, but if they want to vote, hey, let's block that kind of legislation. But I digress. Okay. Now, I was kind of alone on an island when I said, hey, listen, this Rahimi opinion is going to be a big, big problem. And it had nothing to do with the ruling alone. It had everything to do with a bunch of language that was put in there that didn't need to be in there. And this court has, of course, glommed onto it and used it. For example, more recently in Rahimi, the Supreme Court provided additional guidance as to the second step of Bruen's text and history framework. There, the court emphasized its precedent did not require a law trapped in amber, and that the Second Amendment permits more than just those regulations identical to the ones that could be found in 1791. And so with that kind of carte blanche, that as long as you got some objective criteria and as long as it's relevantly similar, and Rahimi kind of lets us just kind of scour all of the history books to figure out what's appropriate here, what the court comes to the conclusion is hey, listen, we've always had a tradition of screening individuals before allowing them to possess firearms, and that's all the FOID card's doing here. Historical firearm laws that restricted the possession of firearms by dangerous individuals while at the same time allowing firearm possession by law-abiding responsible citizens are relevantly similar to the FOID Act. And because it is relevantly similar, that literally provides a state legislature to implement whatever method they want to come up with. And you could think about all the abusive methods that could be implemented, but whatever method they want in order to screen individuals, that is, run them through background checks before they're required to go through background checks. As the appellate court ruled here, further, the historical record shows legislatures traditionally possess discretion to disqualify categories of people from possessing firearms to address a danger of misuse by those who deviate from legal norms. So again, you can see this overgeneralization of the historical analogs that, well, we have always had a history of forbidding firearms from certain people, and that's all this law really does is forbid firearms from certain people. And of course, all we got is objective criteria, which everyone in Illinois will tell you that there's a lot more subjectivity into the equation than meets the eye here. And if you're going through a revocation proceeding, don't even get me started on that. But here, the state of Illinois actually tried to just footnote 9 their way out of it. That's right. They literally argued that, hey, listen, Bruen footnote 9 says that shall issue regimes are constitutional, and that's the end of the analysis right here. As the court framed it, in response, the state does not dispute that the Second Amendment covers the individual's conduct at issue. Rather, it first argues that a historical analysis is unnecessary in the present case because the FOID Act is a constitutional shall issue licensing regime under Bruen. Now, the court here, as bad as this ruling was, did rule the state cannot rely on footnote 9 to obviate the need for Bruen's text and historical analysis in the context of a constitutional challenge to the FOID Act. So I want you to understand that this court was not persuaded that no historical analysis needed to be done. But are there other courts out there that would absolutely positively buy off on this argument? Yes, there are. But of course, since we've already injected Rahimi into the analysis, which means we just need to be relevantly similar, we don't even need to be in the ballpark. We can be kind of in the parking lot next to the ballpark, and that's good enough. Well, then the court can just cherry pick anything that they feel like, surety laws. They provided a mechanism for identifying individuals who posed a threat to public safety and required them to post a bond before carrying a firearm. Surety laws relating to firearms presumed the existence of Second Amendment rights and targeted those individuals likely to misuse firearms. That's right. And the court went on to further state the FOID Act has similar aims and operates in a similar fashion. Like surety laws, the FOID Act has preventative features. It also honors an individual's Second Amendment right to acquire and possess firearms while attempting to keep them out of the hands of dangerous individuals who might misuse them. But here's the deal. Surety laws were used for individuals who had demonstrated a propensity for abuse of these items or criminal behavior, and therefore they were required to post the surety. What the FOID card does, and this is very consistent with how the entire civilian disarmament movement works, is they presume that every single Illinois resident is unlawful or irresponsible, and it becomes their duty to prove otherwise through the FOID application process, because every single individual who wants to exercise their Second Amendment right is required to go through this process in which they must prove their worthiness. And so when you get footnote 9 mixed in with a whole bunch of Rahimi, a court with a straight face can rule, contrary to GSL's assertions on appeal, the state was not required to point to a founding-era firearm licensing scheme to justify the FOID Act. And so in concluding, that requiring citizens of Illinois to get a hall pass from the state of Illinois before they can then go purchase a firearm, or translation, you must go through a background check before you have the ability to go through a background check. This court has found Here, the FOID card seeks to identify those individuals unqualified to possess firearms, for example, felons, the mentally ill, and minors, while recognizing the rights of law-abiding, responsible individuals to firearm possession. Such features are consistent with the principles that underpin our regulatory tradition. But if it's really just as easy as putting on objective criteria to make sure that we're going to do everything that's going to be done at the 4473 background check, then if you take a look at a state like Illinois right now, where you have to A, go through a background check to get your FOID card before you can then go through a background check to buy a firearm at an FFL, what prevents the state of Illinois from then requiring a pre-FOID card, where perhaps you have to, again, just using objective criteria, you have to qualify first before you can apply then for the FOID card. And then a few years down the road, they decide that, well, you must actually first get your firearm safety certificate before you can apply for your pre-FOID card, before then, of course, you can apply for your FOID card, before then, of course, you can go to the gun store and run through a 4473 background check. And of course, each time along the way, because we're using objective criteria, we're subjecting these people to background checks. And that is the very toxic combination you get when you have a court hell-bent on civilian disarmament who wants to mix a little bit of Bruen footnote 9 with a whole lot of Rahimi. Okay, the case once again is Guns Save Life v. Kelly. We'll link it up down below. Remember, Todd and Freedom Steel is linked up down below as well. If you guys got any questions about this stuff or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington Gun Law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.